here in the room, but we're also live streaming this, and we'll have the link to the live stream will be on our league website, but it's also going to be on the Independent Redistricting Commission's website too. So if you have anybody in your at your city or town who's interested in seeing this presentation, they can also link to it after today. It will be both on the IRC's website and the league's website. So just to let you know that. For introductions, my name is Matt Lohr. I'm with the League of Arizona Cities and Towns, and we wanted to do this, this overview of the independent redistricting process because a number of our cities and towns asked us about, as the IRC is going out around the state to get input from stakeholders, our cities and towns mentioned that they wanted to learn a little bit more about the history of the independent redistricting process, and then what the process is this coming year, what the deadlines are, what are the legal requirements, etc. So I asked the executive director, Ray Bladine, and Christina Gomez, who works on the staff, if they would be willing to do this, and they obliged. So we're very appreciative of that. Before we get started, before I make introductions, I just want to let you know if there's any attorneys who are watching this either live on the live stream or who are going to watch this after the fact but on the live stream, you can get CLE credits for this. And to receive your credits, you can go to the league website, which is www.azleague.org, and look under the staff contact page for Joni Hoffman. She's our general counsel, and you can click on Joni's information, send her an email with your contact information, and she will provide the information that you need to get your CLE credit if you're an attorney. So with that, I would like to do the introductions. We have Ray Bladine, who's the Executive Director of the Independent Redistricting Commission, as well as the General Counsel for the Independent Redistricting Commission, Mary O'Grady and Joseph Canfield. And they're going to be talking a little bit about the process, the history, and the current process. So I want to say thank you and turn it over to you.
I get to be first so that I can say whatever I want, and I don't have to worry about them saying everything I was going to say, and they'll be in the position of worrying about what do they want to say because I said it all. But not really. There's a lot of topic here, and all I'm going to do is take a few minutes to make an overall summary of kind of how we got to where we are. It started in terms of Arizona Independent Redistricting Commissions in the year 2000. And in the year 2000, in November of 2000, the voters of Arizona passed Proposition 106, which changed the way the congressional and legislative districts in Arizona would be reapportioned and redistricted. Before that, the state legislature established the lines for legislative districts and also for congressional districts. After the creation of or passage of Prop 106, the process then changed to what we have today. So once every 10 years, kind of like the phoenix bird, we rise out of the ashes and shake our head and try to figure out now what are we going to do, because nobody can remember for sure what we did 10 years ago. Maybe not the best process from an administrative point of view, but from a fair and good government point of view, I think it is a good process. The process starts in this case, it started in the end of 2010, where the appellate court Commission on Appellate Court Appointments, thank you, interviews, it receives applications and reviews those applications for membership on the committee. The Appellate Court Appointment Committee recommends a list of 10 Democrats, 10 Republicans, and 5 independents to be appointed to the commission. Out of that list of 10 Republicans and 10 Democrats, the leadership of the House and Senate of both parties make appointments for representation on the commission. There are 2 Republicans, 2 Democrats, and an independent. The independent comes from a list of 5 that is forwarded to the partisan members, and they make the selection of the chairman. So to be a little more clear, Scott Freeman, who is a Republican and a member of the commission, was appointed by House Speaker Kirk Adams on January 31st, 2011. Richard Sturtz was appointed by Senate President Russell Pierce in February of 2011. Jose Herrera was appointed by Minority Leader Chad Campbell on February 2nd, and he's a Democrat on the commission. And Linda McNulty was appointed by Senate Minority Leader David Sharpa on February 15th. They then came together and interviewed the 5 independents that were put forward and made the selection of Colleen Mathis as chair of the Independent Redistricting Commission. And she was appointed in March of 2011. One of the first things that the commission started to do was go into the process of hiring legal counsel and then also a firm, a consultant to do the mapping. And they hired me too in the middle of the process, but in the way. Joe's right. I was hired in, I think it was April of either April or March, but they had initiated and got started the hiring of consultants. Because the primary work that the commission needs to do, of course, is take a look at all of the state, look at the population changes, and Mary and Joe will go into some of the detail of the kind of things that need to be looked at to redraw districts that meet there's 6 competitive criteria in the Constitution that needs to be met. I know Mary and Joe will go over those. So the whole purpose of the commission is basically to take all of the information from the consultants, look at what the Constitution requires, and then redraw district maps. As a part of that, there's a requirement that that as a minimum, the commission hold a public hearing on a draft map, and that draft map would be available for 30 days. This commission, like the last one, will be holding meetings prior to the issuing of a draft map. Again, I'm not going to go into detail because I know that Joe and Mary will in terms of the process of how the mapping comes about. But basically, we'll be holding hearings starting this Thursday, and I have a list that I'll make available at South Mountain Community College to receive public input on what are important to parts of the community in terms of drawing the legislative and congressional maps. Those hearings will go on to about August 6th. Then the commission will take that information under the Constitution. There will be a grid map presented, which is the starting point of doing the mapping. We're going out before the grid map because last time we hear there was a lot of confusion. The grid map is simply that, taking and drawing grids around, across the state of equal population, and that will completely change once one really starts to look at the demographics of what are in those districts. But we're aware that 10 years ago, there was a lot of consternation of looking at that map and saying, oh my gosh, this does not reflect our community of interest, and it doesn't reflect anything that we think should be the case. Once the input is taken in, the next step would be the creation of a draft map, and that draft map then will be put out for 30 days, and at that time a second round of hearings will be undertaken, probably starting in the mid to early part of September, and again they will be statewide, and again to seek public input and comment on the draft that they have. That's a generalized. After that, there's some other activity that takes place. The state legislature has an opportunity to review and make comment, but the ultimate authority for adopting the redistricting maps is in fact with the commission. I know Joe and Mary will talk about the Voting Rights Act and all of the legal criteria that we must meet as the state of Arizona to secure pre-clearance from the Justice Department, which is something we're required to do. So I don't think I'll go into that. I'll let them talk about it. But as a big overview, that is what the process will be. We're hoping, trying to get to a position that toward the end of October, end of October, we would have a map that could be in a form for adoption. I think that's an ambitious schedule. We'll do our best to meet it, but it's awfully hard to predict how that will go given the amount of people involved in developing this process. Paul.
Will the second round of public hearings be a different set of areas, or will it repeat the same areas? Are you looking to split up the first round and second round to different geographical locations, or repeat the geographical?
A little of each. There will be new locations as our current plan, and going back to some of the particularly the areas that we know it's important for Justice Department that we receive community input, but there would be some additional and some different cities in second round to try to broaden as much as we can the input. Maybe before any other questions before I turn it over to Joe and Mary? All right, thank you, and I'll let, I guess, Joe, you're going next?
I'm next.
All
Everybody
right.
hear me okay? Coming through? Thank you, Ray, and thank you to the League for inviting us here today to tell you a little bit about the legal overview of the redistricting process. I have to say some nice things about Ray, and how fortunate the Commission is, and the citizens for that matter, to have him in this position. Ray comes to the Commission with a number of years of government administration experience, many of them working in city government, and it's been a pleasure to work with him. And so what we're going to do, Mary and I, we actually gave this presentation to the Commission a couple weeks ago, so it's we're sort of repackaging it. We'll probably change it a little bit for your purposes, but we're going to do a high-level overview of the law surrounding the redistricting process, keeping in mind that it is high-level and this can be a somewhat complicated and case law-driven area of the law. So with that understanding, we probably won't get into too many details, and we'll do our best to answer your questions to the extent we can. I'm going to cover the Arizona Constitution, just expand a little bit upon what Ray had just talked about with respect to Proposition 106, which created the Independent Redistricting Commission. I'll talk a little bit about the roles and responsibilities of the commissioners and the commission itself. I'll take you through the 4 phases of redistricting as outlined in the Constitution and defined by the court. And then we'll talk a little bit about the scope of judicial review in the event that the Commission's maps are challenged in court. I'll hit on the one-person, one-vote requirement, which is a pretty straightforward discussion of the fact that districts need to be of equal population. And then lastly, I'll talk a little bit about gerrymandering, both racial gerrymandering and political gerrymandering, and what the law says about those two ideas. Mary, I'll then turn it over to Mary. Mary will cover the Voting Rights Act, Sections 2 and 5, which in and of itself is a pretty substantive topic, given that we are a covered jurisdiction under the Voting Rights Act in Arizona. She'll also talk a little bit about legislative privilege, and I think that. Okay, so with that, I will get started. Before I start, I have to say I forgot that you now have the press offices here in your building. So I was immediately confronted by Paul Davenport of the Associated Press as I walked in and asked me what I was doing. And so is that pretty much every day event for you when you walk in here? So, okay, so Proposition 106, Ray mentioned, it's passed by the voters in 2000. It amends the Constitution, removes the power to draw congressional and legislative district lines from the legislature and puts it into the hands of this independent commission. The commission, as again, Ray mentions, 5-member commission. There's some qualifications for the individual commissioners. No more than 2 of them can be from the same, or at least affiliated with the same political party, and the 5th commissioner may not be registered with any party already represented on the commission. So in the case with the current commission, the first 4 commissioners were affiliated with either the Republican or Democratic Party, which meant that the chair had to be either unaffiliated with either of the 2 large parties or affiliated with one of the other smaller recognized parties. And in our case, Colleen Mathis, the chair, is unaffiliated. The members must be registered voters who have been, their affiliation must be with the same party or without a party for 3 years prior to their appointment. And then they must demonstrate a commitment to performing their charge in an honest, independent, and impartial fashion, and to upholding public confidence in the integrity of the redistricting process. The 4 phases that the commission goes through, the Constitution doesn't actually list 4 phases, but when the Arizona Court of Appeals, in one of the challenges, walked through the process, it divided the process into 4 phases, which is a helpful way to look at the process. So in the phase 1, the commission creates the grid that Ray talked about. Phase 2, they adjust the grid. Then they advertise the maps. And then finally, after receiving public comment, they certify the lines to the Secretary of State. And then Mary and I take over and submit those lines to the Department of Justice for preclearance, and Mary will talk more about that. I'll go through each phase in a little more detail. Phase 1, the grid. Excuse me. The Constitution requires the commission to first create, quote, districts of equal population in a grid-like pattern across the state. During this process, party registration and voting history data are excluded from the initial phase of the mapping. So this is strictly a process of creating, in the case of the legislature, 30 equal populated districts. In the case of Congress, it'll be now 9 equally populated congressional districts. This is where the one person, one vote standard kicks in. The congressional districts must comply with one person, one vote under Article 1, Section 2 of the United States Constitution as nearly as practicable, to quote the Constitution. What that means essentially is that the variance between the districts has to be very little, if any at all. The Constitution really demands that those congressional districts be almost exactly the same population to the extent they can be, and any variance is going to be given close scrutiny by the courts. With respect to the legislative districts, the requirement of the one person, one vote requirement for equal population doesn't come from the Article 1 of the U.S. Constitution. It actually comes from the 14th Amendment, which is the equal protection provision. And it allows a little bit more flexibility in terms of the population deviations than those that are associated with a congressional district. So what that means is that the differences between the districts in terms of the number of voters assigned to each district can vary slightly. And the general rule of thumb that's been followed by the court, I say general because obviously those things are subject to interpretation, has been about a 10% deviation between the smallest populated district and the largest populated district. And even then, if there is a variance, and it may be big for geographic reasons or whatever other reasons the commission determines, the commission will have to explain and justify why there is a deviation. So, because Arizona's population has increased since 2000, the congressional and legislative districts as they exist now are likely unconstitutional. I have to say likely because I'm a lawyer, and even though it's probably pretty obvious that they are, I can never just say that. So moving on to phase 2. So we've created the grid, which again, someone described it as a tic-tac-toe board kind of scenario, although it'll probably look a little bit different than that. But it really is nothing more than just randomly drawn districts of equal population. As the Constitution sets forth, the commission's job now is to adjust that grid to take into consideration several criteria listed in the Constitution. The first 2, and most important, are they must comply with the United States Constitution and the United States Voting Rights Act. Well, I talked a little bit about the constitutional requirement of equal population. That's the one person, one vote standard. Mary's going to go into much more detail about the Voting Rights Act, which really does become quite important in this process. Population equality. Congressional districts shall have equal population to the extent practicable, and state legislative districts shall have equal population to the extent practicable. That's, I'm reading right from the Arizona Constitution, Prop 106, just again reflecting the one person, one vote standard. The next criteria is compactness and contiguity. The Constitution says that the district shall be geographically compact and contiguous to the extent practicable. Obviously, we know what compactness means, all one area. Contiguity means basically they go together, trying to keep districts, populations as compact as possible and not creating districts that may have one area in the northwest part of the state and one area in the south part of the state. So we want to keep them contiguous to the extent practicable. The next item of consideration is communities of interest. The Constitution says that district boundaries shall respect communities of interest to the extent practicable, and that's obviously one of the critical reasons why the Commission will soon be taking its show on the road to hear from the different communities around the state about their respective communities and what, why they believe they should stay together or be part of another community or whatnot. Geographic features. This is relevant to the league since we're sitting here today. The Constitution says, talks in terms of political boundaries and census tracts, and it says, to the extent practicable, district lines shall use visible geographic features, city, town, and county boundaries, and undivided census tracts. So the Constitution encourages that municipalities be kept in the same district to the extent they can, and obviously the extent that the Commission determines that they can do that to balance and still balance all the other goals, which was really the hard part about this whole process. Finally, the Constitution says that to the extent practicable, competitive districts should be favored, where to do so would create no significant detriment to the other goal. So there is this competitiveness requirement too, which I'm sure you've heard a lot about. The IRC's map should make adjustments for all 6 goals that I just talked about, and they will, according to the court, the Commission will do that before they advertise the map. So when they advertise the map, they'll have considered all those criteria to the best they can and put the map out there for public comment at that time. So now we're in phase 3. So they've now advertised the map after adjusting for all those factors. The public comment period is 30 days. During this period of time, the legislature you already heard they had one role in this process by the leadership in each house appointing the first 4 commissioners. Their next role in the process comes at this point, where they now have a constitutional right to make recommendations to the Commission based on the maps as advertised.
So does that mean the legislature as a whole, or does it specify that they have to actually meet together to?
The question was that Joni asked whether that means that the legislature as a whole should comment or whether individual legislators. Is that, Joni, is that essentially what you're asking? I'm just going to read directly from the Constitution here so I don't get this wrong. It says, which during that 30 days, either or both bodies of the legislature may act within this period to make recommendations to the Commission by memorial or by minority report, which recommendations shall be considered by the Commission. So it speaks in terms of the body, and it speaks in terms of minority and majority reports. That's all the Constitution gives us, so may or may not require some interpretation, but right from the source itself. During phase, so now we've finished with the public comment period. The Commission has heard from the public, the legislature, any other interested parties about their advertised maps. They now will embark upon the process of finalizing those maps, which may include adjusting them in consideration of some of the comments they've heard. After the comment period, the Commission establishes the final boundaries. This again is from the Constitution. It then certifies the new districts to the Secretary of State, and at that point, Mary and I begin the process of putting together a submission to the Department of Justice for pre-clearance. I'm going to turn now to this, hopefully what will not be a relevant process or consideration, but given past history may very well be, and that is the scope of judicial review. And this would be what the standard that a court would apply if the districts are challenged. Now, I say that we obviously we would like to avoid legal issues, but it's important to know what the standard is because that's important for the Commission to understand how their maps would be scrutinized in court if challenged. So because of this litigation from the last round, we do have some guidance in this area from the court, and I'll tell you a few points that the courts have made and that is now binding upon the Commission. The first is that we now know that the Commission acts as a legislative body when it draws the lines. So there was some debate about that last round, whether they were an administrative commission or board or whether they acted like a legislative body. And it's an important distinction primarily because depending on what they are, will depend on the level of scrutiny that the courts will give, or I should say deference that the courts will give to their plan. Because the courts generally afford what we call substantial deference to legislative enactments, the court applies the deferential standard of review when a challenge to legislative lines or congressional lines are brought in court. The court will ask the question if the party challenging the plan has demonstrated that no reasonable redistricting commission could have adopted the redistricting plan at issue. So again, highly deferential, the sort of reasonableness commission standard where they'll ask, would a reasonable commission sitting in the shoes of this commission have drawn lines similar to the lines that the commission drawn based on the information provided and presented to them? If so, then the court will not inject itself into the process of trying to second guess the lines and defer to the commission. One thing that the court also settled was what happens if one of the parties presents to the court a map that they think was better drawn than the commission. And that's exactly what happened. The challengers had presented some maps that they thought could have been drawn better to, and I think the issue primarily during the last round was competitiveness, that the challengers felt that the commission could have created more competitive districts. The court said that the fact that a better plan exists does not establish that the plan at issue lacks a reasonable basis. So simply presenting the court with a plan is not going to be enough. The court's going to revert back to that reasonable commission standard that, again, is highly deferential. The court, when reviewing a plan, it will follow a two-step process, and they'll ask the question first, did the commission follow the constitutionally mandated procedure? And that's the procedural issues. Did they draw the grid map? Did they have a 30-day public comment period? So all those procedural requirements that are set forth in the Constitution. And secondly, they'll ask whether the commission adopted a final plan that satisfies the substantive constitutional requirements. And that's when we get into the questions of the competitiveness and the Voting Rights Act and communities of interest and those kind of things. So, when reviewing whether the commission failed to follow the mandated procedure for complying with any of the 6 listed goals, the challenger must establish that the commission failed to engage in a deliberative effort to accommodate the goal or goals. So the court's going to ask, did the commission appropriately deliberate, receive public input, and create a record upon which they could base their final lines? And if so, the court's going to be very deferential. The court will end its inquiry if the record demonstrates that the commission took the goal or goals into account during its deliberative process. Note a couple things about the deliberations according to the court. The court had said that the Constitution doesn't actually require that the commission record any specific information as evidence of its deliberations, but the court strongly recommended that the efforts of the commission to develop a detailed record of its deliberations and to state clearly the reasons for reaching its conclusions will assist the courts in determining whether it followed the mandatory procedure. And not only will it assist the courts, but it will obviously also assist the public in understanding why they have done what they have done. So even though they're not constitutionally required to create this kind of record, the past commission did a good job of doing just that by transcribing their hearings and their meetings, and this commission is doing the same thing. So if anything, there's too much information available. And our most recent commission has taken it even a step further. Their meetings are all Skyped so that they can be viewed on the internet, and then when the meetings are over, those Skype recordings of the meetings are available on the website. So if you want to go back and watch any particular meeting, it'll be available to you, as will the transcript of the meeting itself. I've talked a little bit about this deferential standard of review. We generally refer to it as kind of a rational basis standard of review in the law, but it's really a highly deferential standard the courts apply. There may be an instance where the court elevates that standard of review. And according to the courts, they'll elevate it. They may apply an elevated level of judicial scrutiny to a redistricting plan if a challenge is brought alleging that the plan violates the Equal Protection Clause because the claims generally involve a deprivation of fundamental rights such as racial gerrymandering or vote dilution. But speaking of gerrymandering, I'll transition into that topic, and then I think I'll wrap it up and turn it over to Mary at that point. I'm going to cover two different kinds of gerrymandering. You hear that term quite a bit. Usually when people talk about gerrymandering, they put up the map of the actually first gerrymandered district in Massachusetts that looks like a salamander, and it's named after the governor, who was Governor Jerry. I can't remember the whole story, but obviously it was drawn for a certain purpose to try to bring certain voters into the district. So that's where the term comes from, and it goes back to the 19th century. So when we talk about gerrymandering, it's really the same concept of districts drawn for a specific purpose or reason. I'm going to talk about two different kinds of gerrymandering. One is racial gerrymandering, where districts are drawn specifically for purposes of putting minority voters into certain districts, and then partisan gerrymandering, which is districts drawn for the purpose of putting people of certain political affiliations into districts. Racial gerrymandering, it's defined as the deliberate and arbitrary distortion of district boundaries for racial purposes. And that's according to the United States Supreme Court in a case called Shaw versus Reno in 1993. And what the court said in that case is what involved the challenge, I believe, to a district drawn to pack African American voters into I think it was a congressional district in North Carolina following the 1990 census. What the court said is that when race is a dominant and controlling rationale in drawing district lines, oops. Oh, I'm sorry. That's it. When race is a dominant and controlling rationale in drawing district lines, that's what the courts will consider to be racial gerrymandering. To protect the rights guaranteed by the 14th Amendment Equal Protection Clause, race-based redistricting demands close judicial scrutiny. So it's not that it's necessarily illegal, it's just going to be closely scrutinized by the courts if a challenge is brought. Now, Mary's going to talk a little bit more. This issue is a little bit different in Arizona because, in some sense, as a covered jurisdiction, we do have to take race into consideration when drawing certain districts. So, but I won't get too much into that because Mary's going to cover it. So, if a district is drawn for racial purposes, the court's going to ask whether it was narrowly tailored to further a compelling government interest, and that's really more of a strict scrutiny kind of analysis the court's going to undertake as opposed to that deferential standard I discussed earlier. To challenge a redistricting plan on racial grounds, if you're the challenger and you're alleging that a district was unconstitutionally gerrymandered for racial purposes, you're going to have to establish a few things. First, you're going to have to show that you've got standing, and usually that means that you're someone that resides in the district, so you're affected by the lines themselves. You're going to have to prove that the plan was in fact racially gerrymandered, and if proved, the court must determine then whether there was a compelling government interest in drawing the lines for that reason, and whether the district is narrowly tailored to achieve that interest. So it's a much higher burden. You're going to have to show compelling reasons why you did it that way, and that the districts were in fact narrowly tailored to accomplish those interests. There's a distinction between being aware of race and being motivated by race. So if race is the primary motivation, that's obviously going to be another consideration taken into consideration by the court. Race must, in fact, be the predominant factor to make a claim, a racial gerrymandering type claim. And another thing the court's going to look at is whether there was subordination of traditional race-neutral redistricting principles in favor of race. So those are the things that I talked about earlier that are set forth in the Arizona Constitution, like geographic boundaries and communities of interest and other kinds of traditional redistricting criteria that map drawers usually take into consideration. So when they look at that, they'll ask whether there was. They'll actually look at the shape of the district, and this was something that Justice O'Connor in that Shaw v. Reno case kind of focused on. If it's so irregular and weird looking, that will be a consideration. It won't necessarily be the deciding consideration, but it certainly will be consideration. They'll also look at, of course, the testimony and correspondence that was considered by the entity drawing the commission, and the nature of the data used. So once if the court determines that race was in fact the predominant factor, then they'll then ask whether the the entity drawing the districts have established those compelling state interests that I have noted. Eradicating past effects of discrimination has been a compelling interest, as is complying with the Voting Rights Act. So then the court will then transition into the narrowly tailored provision, which basically says that they cannot go beyond what is reasonably necessary to achieve those goals. So that covers racial gerrymandering. Let me talk a little bit about partisan gerrymandering, and then I'll wrap it up. Partisan gerrymandering. This has been defined as the practice of dividing a geographical area into electoral districts, often of highly irregular shape, to give one political party an unfair advantage by diluting the opposition's voting strength. Although everyone involved in this process and the courts have acknowledged the fact that politics are inherent in any redistricting plan, the issue raised by partisan gerrymandering claims, though, is going to be whether the gerrymandering has reached a level that violates the Equal Protection Clause of the 14th Amendment. The United States Supreme Court has addressed partisan gerrymandering on several occasions, but it struggled with this issue, and struggled with the issue specifically of whether or not the court should even entertain these kinds of claims, and whether or not they're what we call non-justiciable. And that's a legal term that the court applies when it determines that something is really, it's not a controversy that a court is well equipped to resolve. It's something that is better resolved by the other branch of government, the legislative branch. So for decades, I think up until, I think of my timeline here, I think the early to mid 80s, these kinds of partisan political gerrymandering claims were held by the courts to be non-justiciable, and they wouldn't hear them. But then that all changed in 1986 in a case called Davis versus Bandemere, where the United States Supreme Court held that these claims are in fact justiciable claims under the Equal Protection Clause, and thereby opened the door for the courts to hear and rule on claims that a redistricting plan, impermissibly discriminates against a political party. So we got the court saying, if you feel like you live in a district that's been so gerrymandered for political reasons that you believe your equal protection rights are violated, well, the door is open to court to file that claim. You won't be thrown out of court on a motion to dismiss at that point. But it gets a little complicated because proving these claims has been a bit of a challenge, at least at the highest level of the court. The Supreme Court has, even though the court has held these claims can be heard, the United States Supreme Court has been unable to agree on a standard that should be used to adjudicate these claims. 4 of the 9 justices, you need 5 on a 9-member court to create any kind of final binding precedent, but 4 of them concluded that in order to prevail on a partisan gerrymandering claim, a plaintiff must prove both discriminatory intent and actual discriminatory effect against an identifiable political group. Now, how a plaintiff can prove the effects prong of this standard is where it's still unclear. So it's easy to show that the lines were drawn, that the purpose was to obviously create an advantage for one party over another, but proving the effect on it is something that the court has struggled with. So fast forward to 2004, the court took up the issue again in a case called Veith versus Jubiler. They revisited the issue of what standard to apply in a partisan gerrymandering case, but they once again were unable to come up with a 5-justice consensus on what that standard should be. 4 of the 9 justices in that case indicated that because they believe that there are no judicially discernible and manageable standards for hearing those kinds of claims. They said in their dissenting opinions that they would have overruled the prior case, the Bandemere case, entirely, and just went back to the old precedent and said these claims are just not justiciable. They can't be heard because there's no judicially manageable standards to resolve them. There were 3 separate standards proposed by 4 of the other justices, and then the final justice stated that although the pending case, he decided, Justice Kennedy, was non-justiciable, he could not state that all partisan claims were. So that basically meant that we had 5 justices effectively continuing to leave the door open to these claims. They just have never been able to agree on what the standard should be. And they actually addressed the issue again in 2006, but again, failed to provide any further guidance. So, partisan gerrymandering in a nutshell, yes, you can bring a claim. It's just not clear what the outcome will be, and perhaps one of these days someone will help the court reach a 5-justice consensus on what that test will be, or lines will be drawn in such a way that will help the court get there, but we're just not there yet. So with that, I will conclude my portion of the presentation and turn it over to Mary. Thank you.
Make sure I'm on there. Everybody hear me okay? Thanks. It's a pleasure to be with you all here today, and it is a pleasure working with both Joe and Ray. This is an interesting, challenging adventure, representing the commission and helping them develop the congressional and legislative districts. But it is incredibly important work, and for that reason, I'm happy that the League has hosted this event today so that we can help inform the public about how the process works and what the legal requirements are. Hopefully, a lot of what Joe told you about we'll never have to deal with because we won't get sued. But that would be, if that happens, that would be the first time in, I think, Arizona's history that we will have got through decades redistricting with no lawsuits. Since reapportionment. Since reapportionment started, as Joe says. So, but hopefully, that with the state constitution, with the state case law that we have from last decade's redistricting, that should help a lot in terms of the deferential standard that's been developed. That lawsuit at the Supreme Court ended in 2009. If that tells you how long it took to get through the litigation prong last decade. We went from that to getting on to this decade, really. So the Voting Rights Act, and as Joe's presentation indicated, that's really part of everything we do with the redistricting process is make sure that we comply with the Federal Voting Rights Act, which was landmark civil rights legislation enacted in '65 and has been amended and extended since that time by Congress. And I think most of you are probably familiar with the Voting Rights Act and some of its requirements because they do affect the cities and towns as well in their operations. Arizona, in particular, the provisions that apply in redistricting, we're concerned about Sections 2 and Sections 5, and I'll talk a little bit about both. Section 5, the state, as is true at the local level, because Arizona is a Section 5 jurisdiction, we have to get everything, any change that affects voting, pre-cleared by Department of Justice before it can be implemented. So we have to go through that process with our legislative lines. Now, although I'm talking about DOJ pre-clearance, there is an alternative process that the federal law provides for, where instead of going through the DOJ administrative process, the state can bring an action in the District of Columbia federal court to seek pre-clearance. That isn't used very frequently, and Arizona's process has typically been, as most other states across the country, has been to seek pre-clearance through the Department of Justice. So I'd like to talk a bit about that process. The state has the burden of proof. The deferential standards that Joe described that apply to the review under state court standards of the commission's decisions don't apply in the pre-clearance process because the state of Arizona, as a covered jurisdiction under Section 5, has the burden of proving that the redistricting plans that are adopted don't have the purpose and don't have the effect of diluting minority voting strength. And so that applies to intentional discrimination and also accidental discrimination. Any law, so we have to be very careful that our law does not adversely affect minority voting rights. Now, the standard here in determining whether something has an adverse effect on minority voting rights is what they refer to as retrogression. You can't make the minority voters any worse off under the new plan than they were under the old plan. And I guess that maybe sounds rather negative that they were bad off to begin with, because that's not the point. The point is you cannot have any adverse effect on minority voters through the redistricting plan. Now the benchmark, and this is some of the jargon that they use in Section 5, what's your benchmark to determine whether you're worse off under the new plan? obviously they would look at the last legally enforceable plan that was in place. So the commission will do this analysis based on the last pre-cleared plan, the plan they've been using for congressional and legislative districts that the Department of Justice signed off on last decade. Just as there's been litigation every decade, we've had our share of challenges getting our plans pre-cleared by the Department of Justice. In the 90s, when the legislature was responsible for the pre-clearance process and adopting legislative lines and congressional lines, then actually they never adopted any congressional lines. The court ended up adopting congressional lines. The legislative lines there was an objection from the Department of Justice, so that took a while to get legally enforceable lines. Last decade, when the commission was responsible, again, at the Department of Justice, they had an objection to the plan under Section 5, and so it took a while to have legally enforceable lines in place for the decade that satisfied the voting rights requirements. So we hope this time to get DOJ preclearance, just as we avoid litigation, so that we can have legally enforceable lines in place for the 2002 elections and beyond. Now, as I mentioned, it's discriminatory effect, which is the retrogression standard. We also cannot have a discriminatory purpose in enacting the plan. And the kinds of things that justice will look at to decide whether the plans were enacted with a discriminatory purpose, they'll look at the impact on the minority groups that the plan has. They'll look at the historical context in which the plan was enacted. They'll look at whether some procedures weren't followed in the enactment of the plan. And they'll look at the record that's made by the commissioners and throughout the process to determine whether there was a discriminatory purpose evident in the plan that was adopted. So all of the record that is being made as from the beginning of the commission's work is part of the record that will be reviewed as part of the Section 5 analysis at the Department of Justice. The Attorney General is also very concerned about minority input into the redistricting process. And that's an important part of our public hearings. As Ray mentioned, when we've targeted communities for our public hearings, we want to make sure that we get the kind of input that we're going to need to satisfy our responsibilities under Section 5. So they'll look at the extent to which the jurisdiction gave racial and language minority groups an opportunity to participate in the decision-making process, the extent to which the jurisdiction took the concerns of the minority voters into account when they were making the change. So all that record that we make is going to be an important part of whether Arizona can satisfy its burden of proof when we're before the Department of Justice trying to get preclearance of our lines. Because redistricting is such an important, has such an important impact on minority voting rights, the Department of Justice has specific requirements just for redistricting plans. A lot of the analysis is a very detailed demographic analysis to determine whether the minority voting rights have been, how the plan affects minority voting rights. So you'll look at voter registration data, they'll look at election results, they'll do an analysis of whether there's racially polarized voting in the community, they'll look at voter turnout and things to look at that district and determine, okay, is this district, has there been a retrogressive impact on minority voters? Can this district, do the minority voters in this district have the opportunity to elect a candidate of their choice? And that is, Joe and I will do the legal analysis, but behind that is a lot of statistical analysis that Joe and I will not do because we're lawyers, we do the law, and others do the kind of expert type workup of analyzing the election results, the voter registration data, the census data to determine, okay, are we building effective minority districts? And that's the same analysis that Justice will undergo when they're evaluating our plan. They'll look at, are we fragmenting minorities among different districts without justification? They sometimes refer to that as cracking. where you'll have a cohesive minority population that could elect a minority representative, but instead of putting them in a single district, you've split them into two where they don't have an opportunity to elect. And sort of the opposite of that is another potential vote dilution technique called packing, where instead of splitting minority voters into multiple districts, you put them all into one and put many more minority voters than were needed to have an effective minority district. And what you've done, maybe in that case, is instead of having two effective minority districts, you only have one because everyone is packed into that particular district. So that's one of the things that Justice will look at when they're evaluating the plan, and certainly on the front end, that's what we'll be looking at too, to make sure that we are going to be able to satisfy our burden of proof. Justice will look at alternative plans with a slightly different eye than alternative plans are considered under the state constitution. Under the state constitution, alternative plans, if there's a better way of doing things, that doesn't necessarily matter. There's going to be deference to the commission's judgment. At the Department of Justice, we may need to explain why the alternative plans in terms of voting rights, why one was chosen over another, to make sure, again, there's no evidence of a purposeful discrimination against minority voters. They'll also be concerned with, as they are in racial gerrymandering cases and other gerrymandering cases, whether we followed our criteria. Again, in looking at purposeful discrimination, are we following our state constitutional criteria? Are we doing something a little different that suggests what's really going on here is purposeful discrimination? So it's important, even in terms of the Voting Rights Act, that we follow our state standards, so we don't have any problems on that end. Now, there is no obligation under the Federal Voting Rights Act to maximize the number of majority-minority districts. So just because a district hasn't adopted the maximum number of majority-minority districts, that cannot be the sole reason for determining that a jurisdiction had some discriminatory purpose. Because again, they're looking at retrogression. Are they worse off than before? And by law, there's no requirement that you maximize the number of majority-minority districts. Now, how does this process work? That's basically the standard. Those are the kinds of things we'll have to look at when proving to the Department of Justice that we've complied with Section 5, that we've adopted a plan that doesn't have the purpose and doesn't have the effect of diluting minority voting strength. How does the process work? And as some of you know from your work at the cities, it starts with a submission process. After, again, assuming we go through the routine process of going to the Department of Justice rather than filing a lawsuit in Court of District of Columbia to seek preclearance. But after the plan is certified to the Secretary of State, and actually we'll have two plans and two submissions because we'll have a congressional plan and a legislative plan, but they will be separately submitted to the Department of Justice. And the federal regulations detail what the state has to provide in that submission. And they ask for a lot of information so that they can do the kind of statistical analysis that is necessary to evaluate a redistricting plan under Section 5. So it's sort of like in math where you have to show your work. You have to not just give them the plan, you have to give them all the backup so that they can check for themselves that this satisfies the Section 5 requirements. We'll make our pitch in our submission. It has a section where we will explain what we anticipate to be the effect of our plans on minority voters. So that's where we as a jurisdiction will explain why we've met our burden of proof and provide them the additional backup necessary to show that we're right. They'll want to have all the information on our publicity. They'll want to have all the detail regarding how available, open our process was to minority voters, what opportunities there were for minority participation. They'll want our list of minority contacts that we have, and a lot of that outreach is ongoing. We've already heard from some of the tribes have come to testify and at least acknowledge that they're following our process and will be giving us input in the future. And all that's important to the Department of Justice. We'll also make that submission available to the public and so that people can come and review it and see for themselves and critique what we've sent to Justice. And then there's an opportunity to comment at Justice. It's not a formal lawsuit where everybody gets copies of everything that's being said about the issue, but if there, any interested party can send a letter to Department of Justice telling them what they think about our submission. Hopefully they all send letters saying, this is wonderful, please approve this right away. So we hope for those kinds of communications. That's often not the case, and sometimes the Department of Justice may follow up and ask us questions, often based on either their analysis, their independent analysis, or based on some of the concerns that third parties have expressed to them about whatever plan has been adopted. The department has typically 60 days from when they get the submission to make a decision. Now that can change. If they can ask for more information, and if there is a written request for more information, that may toll the time, and so we have to then get them the information, and when we get them the information, then the 60-day clock starts running again. So again, procedurally, that's why on the front end, particularly with a redistricting submission, we'll try and be as thorough as we possibly can to try and minimize the time extensions that are caused when you have requests for additional information. We also often get phone calls, more informal requests for additional information, and if they're just, which don't extend the time. And again, Joe and I'll try and be as responsive as we can, again, because we know that it's important for the voters, for candidates, for election officials, that we get through our process. So there's some certainty as to what the lines are going to be for 2012 just as soon as possible. And there's no certainty until DOJ preclearance is obtained, because we can't implement these lines until we get that preclearance approval. Now, what if we don't meet our burden of proof? Typically, they do give you a shot through a request for supplemental information before filing an objection. But ultimately, if we don't satisfy our obligation to prove that the plan doesn't have the purpose, doesn't have the effect of diluting minority voting strength, then they can object to the plan. And if they object to the plan, it can't be implemented. The state can ask for reconsideration. If they're sort of like courts, usually they've made up their mind when they make up their mind, but there is a process for reconsideration. But typically then it comes back to the jurisdiction to make some adjustments to try and satisfy the objection. The objection does have to identify what the problem was. So you'll get information. It's not just, we object. They'll explain like which area of the state, which district was of concern to them in their objection letter. So that's helpful and helps guide the decision-making process from there. If there is an objection, then typically the commission would go back and make some changes, and then that gets submitted again for preclearance, because we do not yet have a plan that can be implemented. So that's the kind of high priority legal work after the commission finishes its policymaking responsibilities to adopt the legislative and congressional plans, is to get it through Department of Justice. Now, that's not necessarily the end of the voting rights issues. Even if something is pre-cleared, you can get sued for violations of Section 2 of the Voting Rights Act. And Section 2, like Section 5, does protect the right to vote and protects against laws that deny or abridge the right of minority voters. It's different than Section 5. Section 5 only applies to certain jurisdictions that have been identified under federal law. Section 2 applies everywhere. Section 2, however, requires that someone else sue the state, and then someone else has the burden to prove that we violated the law. So the burden of proof is switched. And so we may not ever be confronted by a Section 2 lawsuit. But the way that analysis works is they'll look at the totality of circumstances to evaluate whether this law causes some discrimination in terms of the minority voting rights. And in the context of redistricting claims, to have a Section 2 claim, you have to show that the minority group is sufficiently large enough and compact enough to constitute a majority in a single-member district. And that minority group has to be politically cohesive, and you have to show that in the absence of special circumstances, racial bloc voting has prevented the minority voters from electing the candidate of their of their choice. So they have, the plaintiffs, if they sue under Section 2, have that threshold burden of proof. And then if they meet that, then the court will look at the totality of circumstances, which might include the history of racially polarized voting, the extent of discrimination history in our state, and a whole host of other factors to determine whether indeed there's a Section 2 violation. Section 2 does not prevent a law from taking effect. Again, that's just the Section 5 process that I've described earlier. But it is another way in which jurisdictions sometimes get sued under Section 5, so it's something, or excuse me, under the Voting Rights Act, so it's something we're aware of and watch for during the redistricting process. Another aspect of the Federal Voting Rights Act that affects the way we go about the redistricting process are the provisions regarding language assistance. There are federal laws, and again, because these also govern local elections, you're probably aware of them, that do require in Arizona the use of Spanish language to explain voting changes, and Native American languages in certain counties also are covered by these language assistance requirements. So we are making sure that we comply with those requirements as we prepare educational materials and when we conduct our public hearings in terms of availability of translation services and those sorts of things to make sure, again, we are getting the kind of public input and that we need, and to make sure that we comply with all the federal laws that are applicable in this area. So that's kind of the quick overview of the Voting Rights Act. It sounds kind of, it gets a lot more kind of interesting when you get down to the facts. Right now we're just setting out the standards, but when you get that demographic information in front of you and the voting rights information in front of you, and you got to make the decisions, are we really creating an effective minority district? It's really a fascinating area of law, and then rolling it into all the state constitutional criteria that also are relevant. You can see how this is a very complex decision-making process that's required to develop our congressional and legislative districts. One other issue I was going to touch on briefly, as Joe mentioned, the commission is a legislative body based on the case law that was determined last decade, so there is that deferential standard. There are other implications of being a legislative body, one of which is that they do have legislative privilege that affects maybe not their ongoing operations, but becomes relevant in terms of litigation, and was something they spent a lot of time litigating last decade, but thankfully Joe and I don't have to worry about that this decade because we have case law that has resolved that issue in terms of them being a legislative body and having a legislative privilege. So I think those were the legal issues we wanted to kind of give you broad brush view of this morning, and again, we welcome any questions on those points. And if they're not, did you want to talk more about the public input process?
I might take a minute and just overview what we'll be doing. I have brought, and it is posted on our webpage, all of the hearings that have been set up for the first round. And if you go to the webpage, which is www.azredistricting.org, you can take a look at that. We will also be at each one of these hearings presenting a PowerPoint that kind of summarizes the type of information we provided today. This is not posted yet, but will be after the first hearing, which is Thursday night at South Mountain Community College. And I do have some of those for the audience. I just will back up a little bit. Mary talked a lot about the material that we have to gather and keep record of. We have actually looked at a couple systems to track and record information, and also to be able to analyze it quickly, utilizing a system of inputting the data into a computerized program. So for example, any emails we get in the office, any letters we get in the office, any documents dropped off will all be categorized and will be inputted into the system, which will then be searchable, so a commissioner can go back and take a look at, okay, at this meeting, who talked about competitiveness, what were the issues at this meeting, people talked about community of interest, what were they, there was a map submitted, I want to look at that, and Mary and Joe have been very helpful of looking at systems that primarily, I guess, serve litigation of being able to go back and get documentation, but it really will be very helpful to the commission and the commission staff to be able to categorize and receive that information and help make the commissioners more aware of what parts of the community are interested in. I think.
I have
you
a couple of other things I was going to mention.
Okay.
I was just going to mention the transcripts that I think were referred to that are on the website. Those are word searchable also. So they may be kind of daunting at first, but they are word searchable, if that's helpful. And also if people want to subscribe to the meeting notices so you get them automatically, that's also available on the Commission's website, which is, I think, a nice service for people to take advantage of, so they know when the commission is, because sometimes they meet in different areas. Although we have these public hearings, we also at their regular business meetings often get input, substantive input on redistricting, on what they view as the community of interest, and that's, and so following their meeting schedule can help you, be able to participate in that.
And eventually we will operate a Facebook page when we figure out how to operate a Facebook page. And a Twitter account. The commission wanted to do this at the front end, and I had to inform them. Unfortunately, they hadn't hired a young enough staff member to be able to do that. But we are working on getting that set up. Frankly, we've just been really focusing on trying to get the meeting set up so that we can get out in the community and do all the administrative work that needs to do at the front end. But we are now really starting to move toward the public information part of it, and we will be making that kind of information available also to the public. Anything else, any of you?
One
think
question
about?
out there.
You should.
I have a few. Me too. I guess my first question, which I guess may be a stupid question or clarifying question, everyone refers to DOJ pre-clearance. To me, it sounds like DOJ clearance. What are you pre-clearing from? So it sounds to me like you get clearance from DOJ, and then the commission is allowed to approve their map.
Okay, maybe I wasn't clear enough there. Okay. The question was this word pre-clearance. It sounds more like a clearance process, and I don't know why I'm making that noise, but then a pre-clearance process, right? And just to be clear, we can't submit things to DOJ and the term they use is pre-clearance. Maybe they could call it clearance, but they do call it pre-clearance. But it comes after the commission has approved their plans. They don't look at things until our process is done. So like with legislation, until the governor signs a bill, they don't look at it. That's after she signs it, then we submit it. And I don't know why they call it pre-clearance. Maybe because they can't be implemented until it is cleared or pre-cleared. So it's a clearance process that occurs before the law can be implemented at all. Sometimes the technical language, whether they interpose an objection to the plan, but it's a pre-clearance process. And I don't know why they use that word. Joe, do you want to guess why they use that word? I don't.
I was just going to offer, just to maybe help understand this a little bit better, because Mary talked about how pre-clearance, you might as well just use the word approval. I don't know why it's a technical, but that's really what it is. It's an approval. But the way they couch it, and I've dealt with this for years as an election attorney for the state and then as state election director, because everything has to be pre-cleared. We're just dealing with the pre-clearance aspect of redistricting, but every change to the voter registration form, to the voting laws, everything affecting voting in this state has to be pre-cleared, and that applies to all your municipal changes too. When you submit the change for pre-clearance or approval, what you get back is not a letter congratulating you on the fact that your change has been approved or pre-cleared. It's that they're just not going to interpose an objection a challenge at this time, but they still reserve the right to do that later. So if you don't know that it's good news when you read it, you'd actually think it was kind of bad news. But that is the process.
The next one, I was just wondering if you could go into a little bit more detail about, you mentioned covered jurisdictions in the Voting Rights Act in Section 5, and a little of the background on how Arizona became a covered jurisdiction and how many are there, just to give a scope of how many states don't have to deal with that.
Arizona was added, we weren't one of the original Section 5 states. We became a Section 5 state when they added the minority language assistance requirements. And it was based on our low voter registration and our high minority language population that needs language assistance. And we did have also a history of some, discriminatory practices in the state. But that was, timing-wise, that's when we came in. We are not... most states as a whole aren't subject to Section 5, and I don't have the exact number. It's Arizona, Alaska, several states in the Old South are covered as a whole, and in many other jurisdictions, maybe selected counties are also covered, and I can look in my notes and kind of get a tally of those. But Arizona is one of the minority of states that is covered as a whole. Under Section 5.
There are a lot of jurisdictions, though, within other states, counties, and some municipalities. There's several counties in California, but I think there's 8 or 9 states. I think I can see the map in my head. It goes along. It starts with Arizona as a covered. New Mexico, for some reason, is not. Texas is covered. Louisiana, Alabama, Georgia. Kind of as you follow the South, and then I think parts of Virginia. But if you go to if you're curious, the voting rights section of the Department of Justice's website has a map and lists all the covered jurisdictions.
And I actually have a list here if you're interested in my notes.
I'm genuinely curious. Thank you. And then my last question is, what does the Voting Rights Act say? You mentioned, I've heard, race and language. What about ethnicity and or religion? Is it just the 2 categories, language and race?
It's not religion. Oh, I'm sorry. He was asked, what does the voting rights, what's minority for the purpose of the Voting Rights Act, and whether it includes religious minorities, and I referred to racial and language minorities. Are there others? It's not religion, but it refers to discrimination based on race, color, or membership in a language minority group. And then that's kind of further defined in the law. And here in Arizona, when we're doing our Section 5 analysis, we're concerned with the Native American populations are a significant part of the Section 5 analysis here. The Latino voters are a significant part of the analysis. We also have the African American voters in some areas who would come into play as well. But I think the big issues tend to be in terms of the Latino vote and the Native American vote.
Yes, I just have a little housekeeping question first. What is the targeted population for legislative districts?
I didn't bring that.
I don't have it handy, no, unless it's in here.
We didn't bring the specific demographic information today since we're not yet doing that. So the numbers guys, we didn't bring our numbers guys today. But we do have that information and we can get it to you. I didn't bring it.
Well, while they're looking for that, I'll ask my other question. You said that there's no requirement to maximize minority majority districts, but we have a number of those now. We can't reduce that number, is that correct? That would be retrograde.
Can you ask the question again?
Okay. How I had commented in the presentation that there's no obligation to maximize the number of majority-minority districts, but is it correct to say that because we can't dilute minority voting strength, we can't reduce the number of majority-minority districts? And that tends to be kind of the starting point for the analysis. We looked at, but I don't have my demographic information here, but we do have that information. And as the process unfolds, we will get that to the public. That'll be part of the sort of hands-on analysis where we're giving a detailed analysis of our benchmark and all the demographics for the benchmark, and then comparing that to what we need to do going forward. As I mentioned, that's the starting point for the analysis, because you still need to kind of dig a little deeper and say, you know, was that an effective minority district as constituted, and what impact does that change in numbers have on that district? So you need to be really case specific, but the first version is always looking at the numbers.
Okay, I found you. Can you hear me okay, Stephen? No, I need this one. The ideal population for a legislative district is 213,067 residents, and for a congressional district is 710,224.
And can I comment on that also? One of the things that's unique about Arizona's process as compared to other states is that we do start from that grid map. And that was one of the big changes from kind of the old process. In addition to changing who makes the decision, it used to be the legislature, now it's an independent commission. In the old days, they also started with the old districts. We don't start our lines from the old districts, we start from the grid. So you start from a blank slate. But the tricky part is when you do the voting rights analysis, you have to look at the old maps to make sure you're not being retrogressive. So they're not irrelevant, they're relevant to the analysis, but they're not the basis for drawing the new maps. And as Joe mentioned, we also can't consider like incumbent addresses and that sort of thing, which obviously was relevant when the legislators themselves were drawing the maps, but it's absolutely not a consideration now.
I wanted to follow up on the majority minority districts, and you said that and this is kind of a demographic question, but it's kind of a legal question too. You said they use voter registration and then election analysis to explore the census. Is it the number of people of minority members of that district that are registered, or the number that vote? Because they're, or the number, or the total number of that minority that are in the district.
Well, Joe and I will both kind of respond. And again, it'll be interesting, and I urge you all to pay attention when we get into the nitty-gritty of the numbers and the analysis, and we get, you know, the social science perspective on that. But I think you're looking at voting age population. You're looking, okay, and I'm sorry I didn't repeat the question. Let me go back here. Asking for more detail on what we are looking at in the voting rights analysis. Are we looking at voter registration? Are we looking at who actually votes? Patrice, were there other?
Yeah, how many total number of voting age
Total.
That minority are within that district?
So I think the answer to that is yes. But you kind of look at as you do a pretty comprehensive look. You look at the numbers, you look at the demographics, you look at the you need to look at the voter registration to see if, and you look at turnout, you look at racially polarized voting to see, is this going to be an effective minority district? If you have a minority population, for example, that is, let me see, high voter registration, high voter turnout for whatever reason in that area, they're a very organized group. And perhaps maybe a lot of crossover voting, they may not need as high a minority number to protect the right, the opportunity to elect, as you would in another area where you have low registration, low turnout, and a lot of racially polarized voting. So that's why you look at all that data in trying to come up with your analysis. Joe, do you have anything else?
No, I thought that was a good summary. I mean, obviously, voting age population for retrogression analysis under the Voting Rights Act is going to be critical. And I think Mary nicely summarized the issues that are going to be considered. So.
What's the difference between a competitive and non-competitive district?
That's a very interesting question too. Joe, do you want to do that one?
Well, I'll tell you what, because that is a controversial topic. The question was, what's the difference between a competitive and a non-competitive district? And maybe the best way to answer that at this point, because it's really going to be it's going to be up to the commission to define what competitive means for purposes of their determination, because the Constitution doesn't define the term. I'll read to you what the definition, the last commission, they actually did define it, and I think it's still posted on the website. So why don't I just leave it at that, and without reaching any kind of conclusion, because it's going to be a debatable question that the commission's going to have to work its way through. But the last round, the commission defined competitive to mean that either party or other parties would have an opportunity to prevail in an election. A district shall be deemed competitive if the difference in the judge-it scores, and that was the computer analysis program that they used to, analyzing past races and other things like that, between the two major parties in the district is 7% or less. So, it's kind of technical, and again, this isn't binding on this commission, and it's going to be something that they're going to have to grapple with and consider as a body.
Yeah, and just to supplement that, just as there's a sort of a social science body of thought on how you do the analysis to determine whether something is an effective minority district, and case law on that subject, in terms of competitiveness, there are also sort of political scientists and social scientists who study what is a competitive district. That's why those are the folks who come up with the judge-it scores and different tests. So those are all kinds of things that the commission will have to consider how they're going to make that call. And they do have the discretion to make the judgment.
Are there any issues between trying to comply with the Voting Rights Act and also the Arizona constitutional requirements that's difficult or
Go ahead.
Well, the question was whether there's any issues in trying to comply with the Voting Rights Act versus the Constitution, if they
both at the same time?
are both at the same time. Well, that's hard to say.
I would say no, they're going to do that.
Yeah, they're going to comply with both. And I'll point out that the Arizona Constitution does in fact specifically reference the Voting Rights Act as one of the paramount considerations in redistricting. So, to the extent that it's referenced in the Constitution, obviously the intent was to make sure that they're reconciled during this process.
Question on this debate about the minority districts and when they start actually haggling this out. I mean, will this take place in open session, or will it be in e-session? And will it be agendized, or will you just watch the meeting, and when your area of Arizona comes up, you ready to follow it, or when will, as a person in the city monitoring this, when and how will we know when these topics are going to come up and how to interact?
That's a really good question. I think on the front end, and Ray, maybe supplement, but I mean, certainly at this point, they're getting the public comment on how do you identify your community of interest, and to the extent that there's breakdowns within your community. In Phoenix, for example, we're going to have multiple legislative and congressional districts, so hopefully we'll get some information on the different communities of interest within those city boundaries. So on the front end, we'll have that input. But when they actually get down to drawing the maps, which is the adjustment of the grid to take into account all these factors, certainly they'll have meeting notices that they're going to be having discussions and map drawing. Now, last time I know they had like week-long sessions while they were in that process, where it was a pretty intense, and Patrice is nodding. I think she lived through some of that process. But I think once they get into map drawing, it probably is, for those who care about what the outcome is, to follow that chapter pretty closely. Because it also is so interrelated. You may be thinking here, but whatever change you make in one part of the state, you have to make adjustments in other parts of the state, and so it just makes sense to follow it. And with the web streaming and with all the tools, hopefully it is something that folks can follow even if you can't be physically present at that meeting at that time. Joe, Ray?
I mean, I don't know if your question was asking whether this is going to be an executive session. There's obviously executive session is for very limited purposes, so the discussions are going to be an open meeting unless there's there's a litigation issue or one of the other very narrow exceptions to executive session. So.
Well, no, but no, it's exactly both answers is necessary to follow that, the week-long map session. And then one follow-up question. Our council would like to do a resolution with some basic concepts. Is it something, won't make it by our meeting, but is it something they should do now or wait officially for the public comment when you hit the public comment section? Should we predate the maps or wait for maps to come out? Because I don't know if there's maybe a desire to influence maps or, I mean, what would be the most effective timing for a council to pass a resolution just to make the voice heard?
I'd just say whatever works is the most effective. But having said that, I don't see any reason, if your council has in mind what they have, get it in a map for one, because I think it's going to be a lot easier for the commissioners to look at maps versus people giving testimony, talking about locations. And I'd do both. I mean, I'd go ahead and get it in for the record. We'll categorize it. It will be there. It will be available for them. And then I'd have somebody come to the hearing and present it. At least that, if I were in your shoes, that's what I'd do. Joe, Mary?
I agree. I mean, if the extent that your council has some general principles and considerations it wants to bring to the attention of the commission that don't generally apply to a specific map that's already in existence, then you should get them in, because obviously it's easier for us to manage information now than when all that comes crushing in, although, well, I think they'll do a pretty good job of doing that. And then, when the maps come out, then the council may have follow-up considerations based on, but if they're general about the community and you just want to bring them to the attention for the commission's consideration, then they should do it sooner.
Yeah, and I don't see council doing anything other than general, just given the nature of the council.
I may add, in terms of the process, I know last time they had those week-long sessions with kind of meeting after meeting, and I don't know how we'll structure the timing of those meetings this time around, but certainly, as Joe said, decisions are going to be made in public, limited exec sessions except as permitted by the open meeting law.
I think this might be a question for Ray or perhaps even for the consultants, but I believe the commission approved 9 laptops, and the idea was to have a couple that could go with the software that had licenses. Because my question is, when those maps come out, will that be the only way they're available? Because when you have a map, when you have a map of Arizona, Maricopa's probably going to want to zoom in pretty close to actually see where those blocks, where those lines are being made. So that's my question in terms of analysis prior to going to testify. How would any group, prepare?
Shall I go? Go ahead. Okay. I was going to say, the way, I think we got 12 copies of Map It for both the mapping consultants and the lawyers and the staff, and then for each of the commission members. Soon we will have on the agenda for them to approve a form of allowing public input to mapping to them, and that the public would be able to look at the maps. That decision's probably a week, 2 weeks off, but there is discussion about making available a mapping link that would be on the internet that would allow people to follow and also submit. I'll double check how that's going to work, but that's my understanding at this point.
I want to make sure we understand your question, because you're asking about the extent that the maps will be available to the public. Yeah, and no matter what format the commission ultimately decides, I think what Ray's talking about is a web-based format where members of the public can actually draw their own maps or do that kind of thing. But if the commission, when it proposes maps, it will publish them in a format that will be available for the public to review and navigate around. So I think that might answer the other part of your question. So.
Well, I just want to thank all 3 of you again. I know how busy you are, and this is a very busy time, so we really appreciate you taking the time to come in, to go over the process and answer any of our questions. And just so anybody who's either watching this or the archived version of this, again, If you're an attorney, you can get CLE credit by going to the league website at www.azleague.org and finding Joni Hoffman's email address, and you can email her. With that, I would just like to say thank you once again, and good luck with your process.
Thank you.
Thank you very much.